Why would Eric Smith say, I want to keep the accounts so I can spend them any way I want to?
In the treasurer's office learned that there were actually 4 accounts totaling over $200,000.
If this is a criminal enterprise, it's the worst one in the history of the planet.
Eric Smith was the top prosecutor in Macomb County, Michigan, the man elected to enforce the law. Then investigators found 4 secret bank accounts holding over $200,000, accounts he refused to hand over even when his own county's treasurer demanded them. Why would a sitting district attorney fight so hard to keep control of money that wasn't his? And why, when the pressure mounted, did his office change the account's identification numbers instead of simply opening the books? By the time this story ends, you'll understand exactly what he was hiding and exactly what it cost him.
Derek Miller, if they believed that they could hold the accounts and the treasurer wouldn't, would they try to hide it? Why would they suggest and change the EINs? Why?
For years, Macomb County ran a routine most residents never heard about. When police seized cash and property from drug cases and drunk driving arrests, that money was supposed to flow into forfeiture accounts controlled with strict rules. The funds could only be used for law enforcement purposes, and they were required to pass through the county treasurer's oversight, the same office that manages every other department's public money. It's a basic accountability mechanism. It's the financial equivalent of a receipt trail designed so no single official can spend public funds without anyone watching. For most departments, including the sheriff's office, that process worked exactly as intended.
They were private, they were off the book accounts, not exposed to the checks and balances of normal government, and in particular here, with normal county government. The sheriff got the same drug and OWI forfeiture accounts, all that process. The chief deputy treasurer testified to that. Your Honor, that's
But the prosecutor's office was different. Smith kept these accounts under his own control, outside the county's normal budget process, answerable to no one but himself.
In August of 2018, Eric Smith again refused a request from the treasurer to turn over information related to the accounts. At that point was where he stated that he needed the funds for purposes including funerals and charities, and he wanted to maintain discretion over how those funds were spent. At some point in August of 2018, the treasurer's office learned that there were actually 4 accounts totaling over $200,000.
That arrangement might have stayed hidden forever if the county hadn't launched a statutorily required audit. When auditors reached out to every department asking them to disclose their accounts, one office refused, only one.
The reason is they're hiding the accounts. And that's in the face of a statutorily required countywide audit conducted by Plant Money. That's what was being asked, to reveal the accounts to the county auditors. Every other department, when asked, revealed, except Eric Smith, except the Macomb County prosecutor. And in conversations with the treasurer, both defendants say, we're not changing the EIN.
The prosecutor's office wouldn't reveal what it had. Think about that for a second. Every other department in the county, when asked to show their books, simply showed them. That's not complicated. That's not controversial. It's what public officials are supposed to do. Smith's office stood alone in saying no. When the treasurer pressed further, the picture got worse. Investigators initially believed there was a single account holding roughly $20,000. It turned out there were 4 accounts. Combined, they held more than $200,000, 10 times what anyone expected. And according to testimony later given under oath, Smith told colleagues plainly what he wanted: to keep the accounts so he could spend them any way he wanted.
I want to keep the accounts so I can spend them any way I want to. He also has other county funds that come to him to go through the normal budgeting process. And after that period of time, among others, Derek Miller, Eric Smith get together, talk about the accounts, whether they should turn them over, and agree to change the EINs. That's record evidence.
It's not any way permitted by statute, any way he wanted. Here's where the story turns from a bureaucratic dispute into something that looks a lot more like a cover-up. The treasurer formally demanded that Smith change the account's tax identification numbers back to county issued EIs, the federal identifiers that would place the funds back under normal government oversight. Instead, testimony showed that a subordinate advised Smith he could switch the numbers to identification numbers that weren't tied to the county at all. Smith made the call. Staff were sent to the bank. The EINs were changed. The effect, according to a deputy treasurer's own testimony, was to make it harder for the treasurer's office and county attorneys to even locate the funds.
And there's record evidence from the deputy chief treasurer that by changing the EIs, it impeded the treasurer's and the county's ability to locate those funds. That effort evinces a continued intent to hide the funds because they know what they're doing is immoral. Why would they not use the county mechanism if they thought
When the
they could
treasurer
hold?
demanded the change be reversed, Smith and his co-defendant refused, twice on the record, even after being told directly to comply. Ask yourself something. Have you ever worked somewhere with a boss who quietly operated by different rules than everyone else? Who kept a set of numbers, a slush fund, a side account nobody else was allowed to look at? Most people have encountered some version of that dynamic. The difference here is that this wasn't office politics. This was public money, drug forfeiture and drunk driving forfeiture funds protected by specific state statutes that spell out exactly how they can be spent, for law enforcement purposes only, appropriated through the entity with budgetary authority over the funds. Smith wasn't just resisting a nosy accountant. He was resisting the law itself. The treasurer didn't back down. That's the part of this story that deserves real attention because standing your ground against an elected prosecutor. A man with subpoena power, investigative staff, and the full authority of a district attorney's office is not a small risk. This is someone whose entire career could have been jeopardized by continuing to push a sitting DA for answers. But the treasurer kept demanding disclosure, kept documenting the refusals, and eventually set a deadline, change the EINs or turn over the funds by November 30th, or the county would resolve it another way. That kind of institutional courage, quietly done through emails and formal requests rather than press conferences, is easy to overlook. It shouldn't be. Days before that deadline, Smith closed the accounts and turned over 4 checks totaling roughly $233,000.
Ultimately, the treasurer emailed Eric Smith and stated that the EINs were not changed or the funds were not turned over by November 30th of 2018. The treasurer would resolve this in another way, whatever way that might have been. Then prior to that deadline, apparently, Mr. Smith did close the accounts and turn over 4 checks to the county, totaling $233,000.
On the surface, that might look like compliance, but closing accounts under a forced deadline isn't disclosure. It's damage control. And once investigators finally got a look inside those funds, they found spending that had nothing to do with law enforcement. It's more than $12,000 in a single year gifted to various churches. Spending that directly conflicts with the Michigan Constitution's explicit prohibition on using public funds to benefit religious institutions.
Embezzlements, because they're outlined. But for you, I want to underscore in 2018, he gifted $12,500 to various churches, expressly against the Michigan Constitution, which prohibits that. And listening to
Thousands more spent on pens bearing Smith's own name, money spent on iPads for his children's school, on a school principal later testifying there was no law enforcement purpose whatsoever for that purchase.
That he's pleaded guilty to. In 2017, he spent $4,440 on iPads for his kid's school on the drug forfeiture account. Principal Ellis testified there was no law enforcement purpose from our school. Lori Deli testified anytime a check was from drug forfeiture, I asked Eric Smith.
Tens of thousands of dollars by his own later admission that ended up funding personal expenses.
His kickback scheme of stealing money by spending money from the forfeiture accounts for matters that couldn't be paid by the CTE. He's saving money in his CTE for other purposes. You see, one of them was to personally enrich himself. Tens of thousands of dollars. So by memory serves correctly, what was it, $60,000, $70,000, Your Honor? And it was targeted for personal expenses that he's
And then there's the moment that turns this from a spending scandal into something far more serious, when investigators began looking into equipment installed at Smith's private residence, a home security system, and Wi-Fi upgrade paid for with forfeiture funds. A court ordered the release of records connected to that purchase. According to sworn testimony from the contractor who did the installation, Smith called him, asked to meet in person, and asked him to leave his phone in the car before they talk. During that conversation, Smith allegedly asked the contractor to produce a second, altered invoice, one showing the equipment had been installed at the prosecutor's office instead of his home.
Mr. Weber testified. Mr. Weber entered a guilty plea on this case. He testified that he received a subpoena issued by the circuit court in a separate lawsuit, directing him to produce documents which would have included the receipts and invoices regarding installation of the security system. The original invoice showed that the security system was installed at Mr. Smith's house and paid for. And I believe Mr. Dagg agreed it was the drug account for the security system. William Weber testified that after he received the subpoena, he received a call from Eric Smith asking to meet him in person. He met Mr. Smith at a location in Macomb Township. Mr. Smith asked him to leave his phone in his car, which he did. During their discussion in this establishment, Mr. Smith raised the issue of the invoice and asked William Weber if he could produce a similar invoice reflecting the installation of the equipment at the office and not at his home. William Weber specifically testified that Eric Smith asked him to create a false invoice for the same equipment, the same amount of money, which he did, showing that the work was done at the office and not at Eric Smith's home. Several days after William Weber created the second altered invoice, he met with Gloria Delia, Mr. Smith's assistant, at a cafe in Clinton Township and gave her the altered invoice requested by Eric Smith. Testimony and evidence submitted during the exam rises to the level.
The contractor testified he did exactly that, creating a falsified document with the same costs and the same equipment, but a different location, and delivered it to Smith's assistants. Let that sit for a moment. A sitting prosecutor, the person whose job is to charge other people with forgery and evidence tampering, is alleged to have personally orchestrated the creation of a false invoice to conceal how public money was spent. If that allegation is true, it isn't just misconduct. It's the exact category of crime his office prosecuted every single day. At the preliminary hearing, prosecutors laid out the case for probable cause on 10 felony counts against Smith, including conducting a criminal enterprise, misconduct in office, evidence tampering, 5 counts of embezzlement by a public official, and conspiracy. His co-defendant faced 2 additional felony conspiracy charges tied to the EIN switch. Smith's defense attorney pushed back hard, arguing that if this was really a criminal enterprise, it was the strangest one in history, one where the enterprise never actually profited, where the office itself spent its own money rather than receiving a cut, and where years of budget presentations to county commissioners never triggered a single objection. The defense insisted this was, at worst, a dispute over discretionary spending, not organized racketeering. The judge disagreed. In a detailed ruling, the court found there was sufficient evidence that public money, over 100 church donations worth roughly $50,000 alone, violated Michigan's constitutional bar on religious funding of public dollars. The court found probable cause on the embezzlement counts, on misconduct in office, on evidence tampering tied to the falsified invoice, and on the broader criminal enterprise charge, ruling that the pattern of concealment, the refusal to disclose the EIN switch, and the alleged forged document together supported moving the case to trial. Here's the question worth sitting with if a public official spends money that technically helped his community, funding addiction programs, gifts for needy families, goodwill in his district. But does it in secret, without oversight, and outside the rules meant to prevent exactly this kind of unchecked power? Does the good outweigh the corruption? Or does the secrecy itself prove the corruption, regardless of where the money ultimately landed? In the end, Smith pleaded and was sentenced to 21 months in federal prison, followed by 18 months of supervised release, the maximum available under his agreement.
Therefore, under the actual statutes, court rules, and case law, I am required to finance matters over the circuit court on this charge, and I will therefore do so. Bond and all conditions of bond will be continued while these cases remain pending.
Turning now to the punishment handed down to former Macomb County Prosecutor Eric Smith for his role in a fraud scheme.
A federal judge handing him the maximum sentence of 21 months in federal prison, followed by 18 months of supervised release.
I'd like to take this opportunity.
He apologized to the people of Macomb County and admitted there was no excuse for how the funds were spent.
I'd like to take this opportunity to apologize to the good people of Macomb County who placed their faith in me. I apologize for spending his drunk driving forfeiture funds as I did and is well documented. There's no excuse. I was the boss and should have ensured that proper spending was done and should not have committed these crimes.
Outside the courtroom, his tone shifted.
But outside of court, Smith did not admit to doing anything wrong, only saying he could have handled some things better.
We gave money to churches that were fighting drug abuse, fighting homelessness, fighting domestic violence. I got prosecuted for that. Being prosecuted for trying to prevent crime. And it drives me crazy. And then you could say, why take a plea? Exactly. Well, let me tell you why I take a plea. This has been hanging over my head and my family's head for 5 years. I'm doing construction right now.
He insisted the money had gone to fighting drug abuse, homelessness, and domestic violence, framing his prosecution as punishment for good intentions rather than accountability for broken rules. That gap between the courtroom apology and the parking lot defiance is the story in miniature. The system delivered a verdict. It did not deliver full certainty about whether Smith ever truly accepted what he'd done wrong. The lesson here isn't complicated, even if the legal statutes are. Public money always requires public oversight, and the moment any official, no matter how powerful, no matter how well-intentioned they claim to be, starts hiding accounts, changing identification numbers, or asking someone to falsify a document, the rules aren't being bent, they're being broken. Power without accountability isn't public service. It's just corruption wearing a
Which is
badge.
such a nice thing.
It is exactly what we wanted, and it should send a clear message that no one, not even a person elected at the
If you want to
highest.
see another case broken down like this one, drop the courtroom moment or the case you want covered next in the comments. Subscribe, share this with someone who needs to see how power actually gets checked, and help build an audience that understands the law instead of just fearing it.